Let me now proceed further and let me present you our next speaker, Bärbel Heikelman. We are very delighted to have her for this conference. It's not the first time we cooperate together. Bärbel is very experienced in the area. For over 20 years. She already works for the European Commission, and since 2012 she is part of the team of the Directorate General Justice. Currently, her main field of activity is procedural safeguards for suspects and accused persons. More concretely, Bärbel is responsible officer for the directive on the right of access to a lawyer and legal aid directive, for both of which she also participated in the negotiation process. As you see, she is really the person who knows well the European legislative framework, the one who actually takes part in it directly. I'm very happy to have her here, and also using this possibility, I'd like to remind the attendees that in the question and answer section, which is in the line below, you can ask the question to our speakers. You can ask to Bärbel, Benoit, or me, and also for the speakers who will be talking next. And now, please take the floor, dear Bärbel.
Hello, everybody. Do you see me? I still see Agne. So I will share my screen and open my presentation now. Hello, everybody. My task today is to introduce you into the legal framework on as regards legal aid for children. I'm very pleased to speak in the framework of this conference, which is part of the Legal Aid for Children project. It's actually the second project I'm cooperating with these project partners, and I'm pretty sure that also this project will be a big success. As regards the legal framework, we need to keep in mind that actually 4 different legal instruments apply on EU level. These are the directive on the right of access to a lawyer, which was adopted in 2013 and had to be transposed by November 2016. The directive on the procedural safeguards for children in criminal proceedings, adopted in 2016 and to be transposed by June 2019. And the directive on legal aid, which was also adopted in 2016 and had to be transposed by member states by May 2019. There's also a Commission recommendation from 2013, which applies as regards legal aid for suspects and accused persons, and where there are also relevant provisions on in respect to children. I will come back to that later on. You see already that this legal framework is quite complicated because we have to have a holistic view of a number of instruments, and on top of it, it is important to note that we would need to keep in mind while interpreting these instruments that these have not been adopted at the same time. Actually, the first one which was adopted was the directive on the right of access to a lawyer, followed by the recommendation on legal aid. The third instrument which was agreed upon politically was the Children Directive, and the very last one was the Legal Aid Directive. And this is important because sometimes we need to keep in mind that especially when it comes to the Legal Aid Directive, the Children Directive, the final shape of the Legal Aid Directive was not yet known by the co-negotiators when they agreed their political agreement. I will come back to this when I come to the more particular provisions. So there are three different but interlinked concepts. A right to access to a lawyer, which is a right every child has as any suspect and accused person. The right to assistance by a lawyer under the Children Directive, in particular Article 6 of that directive, and the right to legal aid, which is also touched upon in the Children Directive, but which is the main subject of the Legal Aid Directive. As regards the right of access to a lawyer, there we have a provision in Article 6.1, which clarifies that children who are suspects and accused persons in criminal proceedings have the right of access to a lawyer in accordance with the Access to Lawyer Directive, and that nothing in the Children Directive, and in particular in Article 6 of this directive, shall affect that right. The Article 6 of the Children Directive was built as a self-standing article and mirrors a number of the rights, but we will need always to keep in mind that when we are coming to the right of access to a lawyer, this right fully applies also to children. As an overview, we have the relevant provisions in Article 2, the scope of the directive, Article 3, which is the core right of access to a lawyer in criminal proceedings, Article 4 on confidentiality of lawyer-client communication, Article 8, general conditions when we apply temporary derogations on in respect to Articles 3, 5 and 6, Article 12 on remedies, and Article 13 on vulnerable persons, in particular children. There's also Article 9 on the possibility to waive the right of access to a lawyer. And I would like to stop a bit here because there is and there was a discussion concerning the possibility for children to waive the right of access to a lawyer. And I think there we need to look into more specifically into three different provisions. It's Article 13 of the Access to Lawyer Directive, Recital 26 of the Children Directive, and Recital 9 of the Directive on Legal Aid. And in the view, in my view, which is obviously not the very last view, because the very last view will be the one of the Court of Justice of the European Union, who is the body who is responsible for the interpretation of EU law. In as much as the assistance by a lawyer on the directive as regards children, concerning specific safeguards for children, is mandatory for children, there can't be a waiver. This is because of Article 13, which states that the specific needs of vulnerable persons need to be taken into account. But I think the most important hint is also recital 26 of the Children Directive, which says that where the assistance by a lawyer presupposes, of course, that the child has the right of access to a lawyer under the right of access to the Access to Lawyer Directive, but therefore the application of a provision of Article 20 of the Access to Lawyer Directive, if that would make impossible for the child to be assisted by a lawyer under the Children Directive, such a provision should not apply to the right of children to have access to a lawyer. So I would understand that if a waiver would make it impossible for a child to be assisted by a lawyer, then such a waiver could not happen. Also in the Legal Aid Directive, there's a hint in recital 9, where it says that, which deals with waivers and temporary derogations, and which explicitly states that this is without prejudice of Article 6 of the Children Directive. I know that this is all a bit complicated, but this is because of this interlink between the directive. So we would say that there is no possibility for a child to waive the right of access to a lawyer, in as much as assistance by a lawyer is mandatory under Article 6 of the Children Directive, meaning outside the situation where a proportionality test can be applied by member states. Now I come to the Children Directive and the assistance by a lawyer in the core Article 6 of this directive. As I have already said, this article is drafted as a very self-standing article, and many of the provisions are exactly the same or very close to the wording of the Access to Lawyer Directive. This is in particular the case of the Article 2.6 on the effective exercise of the right, 6.2, Article 6.3, which mirrors Article 3.2 and 3 of the Access to a Lawyer Directive on the starting point and the content of the right to assistance by a lawyer, Article 6.5, which speaks about confidentiality and mirrors Article 4 of the Access to a Lawyer Directive, Article 6.8, which is about derogations from the right to assistance by a lawyer. This is reflecting Articles 3.6 and 8 of the Access to a Lawyer Directive, but there already we have a difference, which is very important, that while applying derogations, member states need to take into account the child's best interests. And therefore, there we have already a different spill, and it is very important that child's best interest needs to be taken into account, and it will be even more difficult to derogate from the assistance to a lawyer of a child compared to derogations from the right of access to a lawyer. Another derogation which is mentioned in the Access to a Lawyer Directive and which can't be found in the Children Directive and therefore arguably won't apply also in respect to the right of access to a lawyer, is the derogation justified by geographical remoteness. Specificities as regards the assistance by a lawyer of a child. There is one provision in Article 6.7 concerning the level of obligation on member states' authorities. This provision states that where the child is to be assisted by a lawyer in accordance of Article 6, but no lawyer is present, the competent authorities shall postpone questioning of the child or any other investigative or evidence gathering act as provided for by that directive for a reasonable period of time in order to allow for the arrival of the lawyer, or where the child has nominated a lawyer to arrange for a lawyer for the child. This provision takes the place or replaces Article 3.4 of the Access to a Lawyer Directive, where the obligation of member states authorities are much lower in respect to adult persons. The difference between both concepts, assistance by a lawyer for children and right of access to a lawyer for adult person, becomes even more important when we look into Article 6.6 of the Children Directive, speaking of so-called derogations, but in essence about a possibility for member states to introduce a proportionality test. This was one of the provisions which were the most debated in the context of the negotiations on the Children Directive, where many people would not have liked to have any derogation or proportionality test when it comes to the assistance by a lawyer for a child, while member states sometimes, many member states also underlined that there might be cases where it would be not proportionate, which would be so minor and would be closed very quickly without consequences for the child, and therefore member states insisted on the possibility to have a proportionality test. The outcome of this discussion was a narrowly framed possibility to proceed to a proportionality testing, headed by a reference to the compliance with the right to a fair trials, and laying down the elements which member states could refer to in relation to a proportionality test, which are the seriousness of the alleged offense, the complexity of the case, and the measures that could be taken in respect to an offense. These are the well-known merits testing criteria, but which adds the child's best interests, which always need to be taken into account as a primary consideration. There's another very important safety net, which says it is compulsory for children to be assisted by a lawyer if a child is brought before a court or a judge to decide on detention, meaning pre-trial detention, and during detention. Another principle is laid down in the last subparagraph, which is also very important, stating that deprivation of liberty cannot be imposed as a criminal sentence unless the child was assisted by a lawyer in such a way as to allow the child to exercise the rights of the defense effectively and in any event during the trial hearings before a court. So this needs to be taken into account also at the moment when a child is facing justice in early stages of proceedings, meaning that in case authorities would already anticipate that deprivation of liberty as a criminal sentence can intervene as an outcome, they should probably from the outset of the proceedings, but at least before the trial hearings, provide for the assistance of the child by a lawyer. I now turn to the right to legal aid as the third concept, and here we have to again to interpret two different instruments, the Children Directive, Article 18, and the Legal Aid Directive. Article 18 of the Children Directive makes a reference to national law and states that member states shall ensure that national law in relation to legal aid guarantees the effective exercise of the right to be assisted by a lawyer. The reference to the national law can be understood or needs to be understood in a very precise way. And there I come back to what I have said in the beginning. When we agreed on that Article 18, the Legal Aid Directive was politically not yet agreed. So the reference to the in Article 18 of the Children Directive to national law means actually that this national law will be the national law implementing the Legal Aid Directive. And this is very important to note. It underlines, however, that the effective exercise of the right to be assisted by a lawyer needs to be guaranteed. And what that means, I will come back to that when I speak about the Legal Aid Directive. The Legal Aid Directive, which has been agreed shortly after the Children Directive, refers in its scope Article 1 to B to mandatory defense in accordance with union or national law. And here the mandatory defense in accordance with union law opens the scope to any proceedings which fall into the scope of the Children Directive. This is very important to know. When it comes to the merits testing, which is subject of Article 4.4 of the Legal Aid Directive and of Article 9 of the Legal Aid Directive, there we need to keep in mind that Article 4.4 and Article 6.6, Article 4.4 of the Legal Aid Directive and Article 6.6 of the Children Directive contain very similar and even identical formulations, and stating that in the first subparagraph of 6.6 of the Children Directive is formulated in a way which is very similar, but referring also to the specific needs of children, which need to be taken into account when applying the merits testing elements stated in Article 4.4. Therefore, these elements need to be taken into account when member states need to determine whether the interests of justice require legal aid to be granted. And therefore, we would also argue that Article 6.6, as it is formulated with the reference to the child's best interest as primary consideration and deprivation as liberty not being a possible criminal sentence, need also to be taken into account when it comes to the merits testing under the Legal Aid Directive. This is also in line with point 12 of the Legal Aid recommendation, which was adopted by the Commission in 2013, which says that legal aid is mandatory where legal aid is mandatory, meaning where Article 6 of the Children Directive applies. The granting of legal aid should be considered to be in the interests of justice. Article 4 of the Legal Aid Directive also foresees the possibility to provide for a means test under Article 3.3 of that directive. Here it refers to objective factors such as the income, capital, and family situation of the persons, the costs of the assistance of the lawyer, and the standard of living in the member state. Such means testing is not in itself excluded when it comes to children, but again, we need to keep in mind point 6 of the Commission recommendation, which recommends to member states that when it comes to legal aid for children, the child's own assets should be taken into account and not those of their parents or the holder of parental responsibility. Last but not least, I would like to draw your attention to Article 4.5 of the directive on legal aid. This is a very, very important provision saying that member states need to ensure that legal aid is granted without undue delay and at the latest before questioning by police or other law enforcement authorities or judicial authorities, or before investigative or evidence gathering acts as referred to in that directive are carried out. So the decision on legal aid needs to be taken very, very early and very, very quickly. And recital 19 of the legal aid directive points out that in case authorities are not able to take the decision on legal aid before a questioning or evidence gathering, even at early stages of police investigations, at least emergency or provisional legal aid needs to be provided for the suspect or accused person, or in that case, for the child. So as a conclusion, I would say that we have quite a strong legal framework for the assistance of children and legal aid for children, meaning that even though proportionality tests and means testing might be taking place, the child best interests have to be the primary consideration. And obviously also the provisions on the necessity to provide for legal aid whenever it comes to a potential decision on pretrial detention or during pretrial detention, or whenever the deprivation or of liberty as a criminal sentence might be at stake, legal aid and assistance by a child need to take place and to be ensured by the member states. I think that is basically it. Obviously, all this legal framework is rather complicated and rather complex, and eventually it will be for the Court of Justice of the European Union to interpret the interplay of these different legal instruments. We are looking forward now to seeing these directives fully implemented by the member states. The transposition periods ended for all of them, and the Commission is currently busy in checking the compliance and completeness of the transposition by the member states.
Thank you, Barbel, for the informative presentation. You gave us a lot of insights about the work of EU Commission, and also your presentation was very useful because it gives us a map of EU instruments and interconnection of the different provisions of EU directive, which sometimes are hard to understand, and if you don't have this presentation like yours in front of your eyes. So you helped us a lot. Thanks. And I believe there will be questions later on from our participants. As we are tight